stand was that some offenses were not bailable because they were of the opinion, the lawmakers were of the opinion that they were serious offenses and they attracted higher sentences, some of them up to life or death, or maybe something like rape, maximum of 25, minimum of 5. So they took it into consideration, and looking at that time how frequent those offenses were committed and those people involved, then they said that we should make some offenses not bailable. So until you were tried, or even though we said it was not bailable, there were decisions that where the person or the trial delayed unreasonably, then the High Court could admit those persons to bail. Even though we said they were not bailable, still there was a proviso that where the trial delayed unreasonably, the High Court could admit those persons to bail, depending on the available circumstances and facts. In fact, that may persuade the court.
Could it also be the reason, the fact that those offenses, because they attracted higher sentences, the suspects were more likely to jump bail? That was why the law...
It was one of them, but not the core. The core was that, looking at the seriousness of those offenses, let them be in custody. Let them go through trial. If at the end of the day they are acquitted, then they'll have their freedom. If they are convicted, they will be in custody, because the law has made a provision that where you are in lawful custody in respect of an offense and you are convicted, then the court, in imposing appropriate sentence, should take into account the period that you spent on lawful custody before the conviction. So
the reasons you have brought up or indicated why the old law stood for a long time, it sounds quite reasonable and justifiable. So why then did the courts decide that let's change it, let's change the position?
All right. Ghana, we have our fundamental law. That is the Constitution of Ghana, 1992. And it says that the Constitution is the supreme law on the land. And any other law found to be in conflict or inconsistent with any provision of the Constitution shall be void to the extent of the inconsistency or the conflict. So, the Constitution, by its Article 19, provides that an accused person is presumed to be innocent. If I'm presumed to be innocent, why should you enact a law, a lower law, an act of parliament, to say that even though I'm innocent, I cannot be admitted to bail? Then there was a clear conflict. Yeah. So Martin Pebu, a legal practitioner in Accra, went to the Supreme Court for his interpretative opinion. And Supreme Court compared the Section 96(7) of Act 30, which is an act of parliament, which is subordinate to the Constitution, and came to the conclusion that indeed it was in conflict with the Constitution. So it is not a fact that Supreme Court on its own decided to say that I'm changing the law. No. Mr. Martin Pebu went to the Supreme Court to invoke its interpretative jurisdiction. And the Supreme Court, in its wisdom, came to the conclusion that indeed the subordinate legislation, because when we talk about Act of Parliament as against Constitution, it's subordinate, it is inferior, it is lower. And once they are in conflict, then Article 1(2), that is clause 2 of Article 1 of the Constitution provides that where a law is in conflict with the Constitution, then it is void to the extent of the inconsistency. So Supreme Court decreed it void to the extent of the inconsistency. And what we must understand is that when we talk about bail, bail is regulated by a whole section, Section 96. And the 96, it had 7 subsections, 1, 2, 3, 4, 5, 6, 7. But the Supreme Court only struck out the 7. So we have Section 96, subsections 1 to 6. What has been struck out is the offenses which are not bailable. Even the bailable, non-bailable offenses, before they were struck out, initially we had only 96(7). But in 2002, the law was amended to include extradition. So that was why we had the 96(7)(a) and the B. So it is the it is the whole 96(7) which has been struck out. Now the courts are still left with the 96(1) subsection 1 to 6, and that regulates whether bail should be granted or not be granted.
Okay. But one of the things, or two things we have established right now so far, is bail is free.
That is so.
All offenses are bailable.
But it is at the discretion of the court. A court shall refuse to grant bail if it is satisfied that the defendant, who is the accused person, A, may not appear to stand trial, where the court is satisfied that if you are admitted to bail, you may not appear to stand trial, the court will not grant you bail. B, may interfere with a witness or the evidence, or in any way hamper police investigation, where there is a clear case that this man, this woman is likely to influence witnesses or to influence the police investigator or to prevent him from investigating, and the court is satisfied, the court shall not admit you to bail. Right. Then the third one, you may commit a further offense when on bail. Where there is evidence that you may commit a further offense when on bail, the court will not grant bail. Then the D, is charged with an offense punishable by imprisonment exceeding 6 months, which is alleged to have been committed while the defendant was on bail. You were on bail, then you went and committed an offense. And that offense, if you are tried and convicted, you may go in for 6 months. Then that one, the law says that the court shall not admit you to bail. So there are other circumstances that we take into consideration. And let me take you through the 96(6)(2), which is equally important, paramount in this discussion. Then, quote, in considering whether it is likely that the defendant may not appear to stand trial, the court shall take into account the nature of the accusation. The nature of the accusation. B, the nature of the evidence in support of the accusation.
All right.
C, the severity of the punishment which conviction will entail. D, whether the defendant, having been released on bail on a previous occasion, has willfully failed to comply with the conditions of the recognizance entered into by the defendant on that occasion. E, whether or not the defendant has a fixed place of abode in the Republic or is gainfully employed and is gainfully employed. Then the F, whether the sureties are independent, of good character, and of sufficient means. So we have these considerations. The fact that we say that bail, every offense is bailable, we are still governed by rules.
Okay. Now let's move on to a number of issues that have come up since we put out the program, the Bail is Free program. We have had several questions. Most people think that, yes, we're talking law, and but that doesn't really apply. Now, people have a problem, or members of the public or complainants will tend to have a problem where they have reported or complained to the police or reported somebody to the police, and the person is put behind bars or put in cells. And then next thing they know, the person is walking free. And they're like, why is the person walking free? When I reported the person, you don't tell me that you're letting the person, or granting the person bail. Can you please explain under what circumstance this can happen, or whether these people who complain about the conduct of the police have a case?
Very good. When a case is reported, the complainant, you remain a complainant. You are not a party. We should draw a distinction being reporting a case and being a complainant and a possible witness and not a party in the case. In every criminal case, it is titled now, Republic against the accused person.
Okay.
We do not say the complainant against the accused person. The complainant, when you are called in court to proffer evidence, you are called as a witness for the Republic of Ghana. So when it comes to the consideration of bail, it is the police, where it is at the police station. Where it is YOCO, it is the YOCO. They may decide without reference to the complainant. You have reported the case. They are investigating, and they exercise discretion within the context of the law. And you cannot say that I reported, so by virtue of that, I'm using that opportunity to take away your discretion, which is exercised in in consonance with the law. So the question of bail, where it is an inquiry bail, it is decided by the police within the context of the law, YOCO within the context of the law, and when it is in the court, it is the court which decides. The court is not bound to even make an inquiry from the complainant.
Now, has there been any instance where someone is alleged or has alleged that they've paid money to the police by way of bail, to be admitted to bail, and as a result, they've had to come to the courts to seek or to report the case? Or to
Personally, I haven't come across any one of them. But it is a criminal offense. It is corruption, where a police officer demands money from an accused person or a suspect for consideration of bail. It is a criminal offense, and it is provided for by the law. Even though we say that corruption is a misdemeanor. Misdemeanor means the law generally is that that you may be in prison not exceeding three years. But with respect to corruption, the law says that even though it is misdemeanor, if you commit, you demand for bribe, and any one of them, and it is found out, and you are tried and convicted, you may be imprisoned up to 25 years.
All right. Now, when this happens, you're supposed to go to the police, but probably it's the same policeman who took the money.
So, for example, if a policeman at Adenta takes that money from me or demand the payment of that money from me, nothing prevents me from going to the region to report, or to even at the national headquarters to report. And I know that the police has institutions, PAPs, and what have you. You can go and report to any one of them, and they are bound to accept the complaint, investigate, and proceed with the matter.
Beyond going to the police, or apart from the police, is there any other institution you can go to?
Yes, you can go to SHRAJ, Commission on Human Rights and Administrative Justice, to report. You can even go to YOCO to report. These are the bodies that they must hear, investigate, and take appropriate action against you.
How about the special prosecutor?
The special prosecutor, you can, but we must admit that its function is limited to corruption, and the corruption has been defined. So it cannot go beyond the powers conferred on him by the law. Right. You know, when you are established or created by law, you must operate within the law. So if it is within one of the offenses which special prosecutor, that is corruption, to handle, you can go and report. They will assume jurisdiction, investigate, and prefer appropriate charges against you.
Now, from the conversations we've had, a lot rests with the station officers and the station commanders. But are they adequately equipped with the law to deal or handle some of these issues?
They should. It boils down to education, knowing the fundamental human rights of the people. You know, all the things that we are talking about, right to life, bail, all these things come within the purview of fundamental human rights. Because the Constitution says that the accused person hasn't done anything wrong unless the accused person himself pleads guilty or he's proved guilty. So when we talk about fundamental human rights, they are rights, inalienable rights. We were born with it, and nobody can take them away from us unless it is taken in accordance with the law. So if you are depriving me of my right to go to my house, of my right to go to work, then you must do it in consonance with the law which says that I have acted contrary to this provision, and you have every right to take that right away from me. If you look at the Constitution, the whole chapter 5, that is from Articles 12 through 33, they are on fundamental human rights. Martin People's decision was decided on Articles 19 and 14. They are part of the fundamental human rights. That was why Supreme Court struck out at Section 96(7) as being in conflict with those provisions, which are part of the fundamental human rights provisions. So they are very, very important. And the police, they give them education. And apart from giving them them education at the training. They have regular education. They have sensitization programs. Occasionally, they invite the Judicial Training Institute to help them train. Occasionally, they bring them to the court to observe proceedings. After that, then there is a meeting for them to appreciate what goes on in the courts. So taking all these things into consideration, I may come to the conclusion that they know what they are supposed to do. But you know, everywhere you go, wherever you may find yourself, you may have the bad nuts. And until the bad nuts are cleared from the system, you will continue to have this infraction. Don't take money, they will take money. Bribe is forbidden. It is a criminal offense. Apart from being criminal offense, it is against the police code of conduct. So
bail is free.
It is free. But who is reporting? The problem we have in Ghana is that even where an offense is committed and you are to report, then the next thing is that if I report, what should be the consequences?
Yeah.
So we must do away with this bad practice that, oh, this one has intervened, this one has come to plead with me. The system of Jantua, always Jantua, we come, please, we beg, this one intercede. The intercession must stop. Once we continue to embrace, to encourage this intercessory parties, then we will always encourage the bad nuts to continue to take advantage of the people in the system.
Now, the bit about how the public, is supposed to handle itself and to, challenge unlawful practices, it's all well and good, but you'd appreciate that in our society it becomes difficult. If you're seen to be standing up to authority, it is not acceptable. So how do we deal with it?
First and foremost, we must understand that culture is not static. Culture is dynamic. Culture develops. The bad practices, the bad cultures, we should weed them out. Because if a policeman takes bribe from me, and the culture is that, oh, if I report, the others will turn against me. Report for the others to turn against you, and those who turn against you, you report them to higher authority. For example, if it is at the police station, the most senior officer there is the chief inspector. Let all of them turn against you. Go to the district, go to the division, go to the region, go to national.
But they may turn against you in a way that you won't be in a position to go.
It is impossible because, our tradition has been that this is the practice, this is the practice, this is the fear. We must take bold decisions to do away with bad cultures, with bad practices. Without that one, the nation will not move.
I would like you to end on what we are supposed to do as members of the general public. What are our responsibilities?
Now we've talked about the rights of the individuals, right of the citizenry, then rights go with responsibilities. Then you must have your duties too, the duty to perform, because the duty that you said a moment ago, and they have been spelled out in Article 41 of the Constitution. If you have your Constitution, you give it to me.
Yeah.
It has set out the duties on every citizen, and it comes under the directive principles of state policy,
which you're going to read to us.
Yes,
in a
the
bit.
duties of a citizen.
Right.
Article 41, I quote, "The exercise and enjoyment of rights and freedom is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen, A, to promote the prestige and good name of Ghana, and respect the symbols of the nation. B, to uphold and defend this constitution and the law. C, to foster national unity and live in harmony with others. D, to respect the rights, freedoms, and legitimate interests of others. And generally, to refrain from doing acts detrimental to the welfare of other persons. E, to work conscientiously in his lawfully chosen occupation. F, to protect and preserve public property and expose and combat misuse and waste of public funds and property. G, to contribute to the well-being of the community where that citizen lives. H, to defend Ghana and render national service when necessary. I, to cooperate with lawful agencies in the maintenance of law and order. J, to declare his income honestly to the appropriate and lawful agencies and to satisfy all tax obligations. And K, to protect and safeguard the environment. Unquote. Now, everything, all of them have been spelled out here. If you are a policeman, you are to work conscientiously in your choosing occupation. Each and every one must contribute to national development.
Very enlightening notes. We would want to bring the show to an end. But thank you very much for making time to join us, Justice Dennis Adjei. This has been a law class, essentially. Thank you very much once again for making time.
You're welcome.